This is Barry Zalma, Zalma on Insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of this videos. Today I'd like to talk about Volume 24, Issue 20 of Zalma's Insurance Fraud Letter, which is published on October 15, 2020. 24 years, almost 25 years of publication. And the first thing I'd like to talk about is the need to vote on or before November 3, 2020. It is imperative that everyone votes. Although I have my preferences and I will exercise the right and obligation to vote, I hope you all will do the same. Now, this issue starts with a story about an unlicensed doctor who was convicted of insurance fraud and other crimes. After Patrick E. Usanga was convicted for many crimes of fraud, he appealed his conviction unsuccessfully and then filed a post-conviction Relief Act motion to set aside the conviction in the case called Commonwealth of Pennsylvania versus Patrick E. Usanga. The court took the following factual background and procedural history from its independent review of the record and concluded that Usanga, a Nigerian-born United States citizen, obtained a medical degree from the University of Guadalajara in Mexico in 1982. He took the board examination to be licensed as a medical doctor in Pennsylvania several times, but did not pass. On May 19, 2009, he filed the necessary paperwork to incorporate a healthcare facility called Northeast Behavioral Medicine, Inc., with himself as the sole officer of the corporation. He applied for and received a license to operate a psychiatric clinic soon after incorporation. At all times during the period of time Northeast Behavioral Medicine was in business and seeing patients, Usanga was the only provider of the facility. The court convicted him of one count of making false statements regarding an unemployment compensation claim. On May 20, the court sentenced him to an aggregate term of incarceration of not less than 6 nor more than 12 years plus 5 years reporting probation. After his post-sentence motions were denied, Usanga appealed to seek help from a higher court only to be refused again. Usanga, as a last effort, claimed his counsel was ineffective, and that failed. Failure to prove any prong of the test where the underlying claim has arguable merit, no reasonable basis existed for the counsel's action or failure to act, and that the defendant suffered prejudice as a result of counsel's error, must conclude all three existed. Since Usanga's claims were meritless, the court refused to find counsel ineffective. It seems that those who defraud insurers are people with unmitigated gall, and even when they have been caught, have been tried and convicted by a jury of their peers, they will continue to bother and annoy the court system until the courts get so annoyed that they let him out of jail. The Pennsylvania court refused to honor the stupidity of the claim for post-conviction relief, but still had to take the time to review the pleadings and briefs and write an opinion. If he has any of his ill-gotten gains still available, Usanga should be assessed sanctions to remove from his control all of the monies he took from the insurers and pay indemnity to those who allowed him to treat them as if he were a licensed physician. You should read the entire story by clicking on the links to the insurance fraud letter and subscribe. Also, we discussed judgment against an insurance fraud perpetrator was not dischargeable in bankruptcy, where a bankruptcy court in Robert Livingston versus Robert Livingston and Invada Collins, debtors, the United States Bankruptcy Court of Hawaii dealt with the situation where the people seeking bankruptcy protection had been convicted of fraud and had been assessed $222,556.39 in penalties and assessments. The court concluded that there was no possibility of discharging a debt for fraud, that the misrepresentations made by the debtors that resulted in their fraud conviction was sufficient to bar them being able to discharge the debt in bankruptcy. Therefore, the $137,642.39 in fees and costs awarded by the New Jersey court was non-dischargeable, in addition to the underlying award of $80,000. Insurance fraud is a felony crime, and when a judgment is assessed against the fraudsters for their fraudulent conduct, it is unreasonable and unfair to the state and the victims of their fraud to allow the fraudsters to avoid the penalty by discharging the debt in bankruptcy. Even asking a bankruptcy court to discharge the debt was a direct result of the fraudulent and criminal conduct and was a perfect example of chutzpah, Yiddish for unmitigated gall. Allowing a discharge would allow the fraudsters to profit from their crime even after they were convicted. The newsletter also includes a report of good news or convictions from the Coalition Against Insurance Fraud and a lengthy article on the adjuster or SIU investigator's use of an expert, which is necessary to not only convince a trier of fact of a fraud, but protect the insurer against claims of insurance bad faith. By retaining an expert and relying upon the expert's conclusions, an insurer can rest safely in their decision to deny a claim, and even if the court later finds that they denied it in error, the use of the expert will establish the good faith of the insurer, whether that expert is counsel, a lawyer with experience, an engineer, a physician, or any other sincere type of true experts. The newsletter also reports on health insurance fraud convictions, including the conviction of a school teacher and school custodian who were sentenced for insurance fraud benefits fraud, along with almost 20 other defendants in the same scheme, why a ringleader of a Gloucester City drug ring admitted to trafficking illicit drugs and SNAP fraud by using what used to be called food stamps to pay for his fraud, why a West Virginia physician admitted to illegally distributing drugs, why an East Tennessee woman was sentenced to federal prison for forging prescriptions, why 2 defendants agreed to plead guilty to a multi-million-dollar Medicare fraud scheme, how a former professor was sentenced to prison for stealing cancer research funds, why a physical therapist was sentenced to 2 years in prison for a scheme to defraud Medicare and Medicaid, and why a doctor was sentenced to 90 months in federal prison for insurance fraud, how a judge dismissed $18 million in liens filed by a California medical provider that was convicted of fraud, and establishing that the $18 million in lien claims were fraudulent. Other insurance fraud convictions included a person guilty of workers' compensation fraud, a woman who faked her own death to avoid insurance fraud conviction and was sentenced for obstruction of justice, how Joel Gray Jr. was sentenced to life in prison for murder, dismemberment of his parents for life insurance money, why a structured settlement swindler with Kennedy ties was sentenced to prison, and why a runner or capper was sentenced to 1 year in prison for his role in an insurance fraud scheme, how a man broke his teeth with pliers in a Las Vegas insurance scam, and why a Wisconsin insurance commissioner revoked an agent's license for defrauding his consumer customers. The full article and newsletter is available in Adobe PDF format from my blog, zalma.com/blog, and other links available from my website. If you found this video to be of interest, please subscribe to the blog and the newsletter and my videos on YouTube or rumble.com. Thank you for your attention.